Is it affected?
Sir, yes, sir. Yes, sir. It has started.
It has started. Okay. Okay. We will start now then. Yes. Yeah. So far, we have dealt substantially. So all of you understood what exactly is the role of Evidence Act. Hmm? Those of you did not come or may not have come, they know the definition of evidence from the various definitions of various authors. दिए हैं तो सीख चुके हैं आप. The our Indian Evidence Act, that Taylor is the gentleman, the English author responsible for introducing the concept of evidence in England, and Sir John Stephen has followed this here in India. Then we have specifically dealt with how the Evidence Act is applicable to which forum, which not forum. That section 1 explained to you. It applies to all the courts. Definition of court is given in Evidence Act. All judges and magistrate authorized to take evidence, and but not the arbitrators and not the tribunals who cannot take it. They are exempted. वो सीख चुके हैं हमने application. And I also brought to your notice that Evidence Act is not not a exhaustive act. There are rules of evidence are also contained in various other enactments, such as the Code of Civil Procedure, CRPC, Bankers Evidence Act, Commercial Document Evidence Act, then Limitation Act, then Regulation Act, Representation Act, then as well as some provision in the Transfer of Property Act. There are various enactments, even Stamp Act. There are various, even negotiable instrument acts. I read out to you some of the provision, such as 118, 138, 139, and 145 पढ़ चुके आपने. So this act likes to consolidate all the various acts. So you have understood the definition, what is relevant, what is fact in issue, definition of evidence. Then I explained to you what is oral evidence, what is documentary evidence, what is primary evidence, what is secondary evidence, what is presumptive evidence. We also learned proved, disproved, and not proved. In a trial before the court, both in civil and criminal court, the court is not just going to rely upon the evidence, but all matters before it. I gave you an example. Matters before the court, such as the commissioner's report, the bailiff's report, any other matter, deposition we may come on record before the court of law. The items which are not defined as evidence in the Evidence Act or any other document, the court embraces a wide range. Then we dealt with the provisions of Section 4, may presume, shall presume, conclusive proof. So may presume examples, we gave 114 of the Evidence Act, where natural presumptions are drawn. In the natural presumptions, if one of the parties, it is the party who asserts to prove a particular fact, he has to lead evidence. That is also the mandate under the provisions of Order 14. Then also onus under the provisions of Section 101, 102, 110 of the Evidence Act. For proving a particular fact, you leave it, and the court will consider the entire matter. Like, for example, the plaintiff will assert in examination chief that he will seek a declaration that he is entitled to. So he will lead evidence, and the court will presume facts and consider all matters before it. So he will prove facts. And the defendant is interested in denying the fact, he will disprove them. For disproving mean, he will raise a plea that the suit is not maintainable, suit is barred by limitation, the court has no jurisdiction. So he will bring before the court of law material which the court will consider broadly to dislodge the suit and the matter. In neither party, plaintiff or defendant, अगर दोनों भी evidence नहीं lead किए हैं court के अंदर, then the court will hold that here the issues which have been framed are not proved, and the suit stand dismissed. So the proved, not proved, and disproved are three items which you as a young lawyer will immediately come to know. When pleadings होने के बाद issues frame हुए हैं, lead evidence as per in conformity with the provisions of your pleadings which are framed under Order 14. Okay. OCK. Then under the CRPC 211 से लेके 219 the charges are framed are your issues in the matter. So you learn this may prove shall. Then I gave you example of may presume in 114 से लेके section 90 से लेकर 78 से लेकर various we ran through almost substantially many provision. Then to prove a shall presume, I gave you examples under section 78, 79, 80, where memorandum prepared by a magistrate is a court shall presume to be valid. A postal letter which has been dispatched is a court shall presume. A judicial act which has been performed, the court shall presume to be correct. There are many aspects, very coffee, we have big narration of the fact. Then I gave you the examples of conclusive proof. So in both may presume, shall presume evidence, the other side has a right to disprove it by lodge by leading evidence called evidence in rebuttal. But as regard conclusive proof is concerned, in the Evidence Act, just there are three sections. One, section 41, which speaks of a final judgment and decree given in matrimonial case, final judgment and decree given in probate cases, admiralty cases, and insolvency cases. These are the four examples. It must be a final decree and judgment which a party can rely upon. Say that a decree of divorce has been passed. So the question of claiming the document can straight away be produced. Unless the other side takes up the plea that the document, the so-called decree, has been obtained fraudulently. Section 44 permits. Otherwise, in the absence of a fraud, you are not permitted to lead evidence in rebuttal under section 41. Then 121 में आपने पढ़ा a child born, legitimacy of a child 280 days के अंदर separation में पैदा हुआ, the court shall presume that he is legitimate child of he is a father, unless the father takes up the plea that he had no right to access with his wife, he never had any intimacy. That is the. Then 112 में we learned the accession where the territories have been annexed. The notification issued by the government with regard to a territory has become part of a particular state, Union of India. Under the Constitution of India, you know that here India means union of states. Union and the various states constitute the Bharat. So the each state which has been annexed, I gave you an example that year prior to independence there were 600 states in the dominion of various Maharajas and Nawabs. They are all acceded to India. So their accession, their instrument which of accession is court shall presume is a conclusive proof. Okay. Today's topic will be we are dealing with the chapter 2 of the Evidence Act, which is a very important topic. That is, you are entitled to lead evidence in the court of law only in respect of fact in issues and relevant fact. Okay. Please note that this chapter. So the definition सीखे आपने. Now we will go through that here. Now open section 5. We will read section 5 and explain to you with the connecting section. I will connect it with both the CPC and CRPC. Chapters 2, section 5. Evidence may be given of fact in issue and relevant fact. So definition you have seen. Then evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue or other facts as are hereinafter declared to be relevant and no other fact. So to understand section 5, you should know that fact and issues can be seen, can be determined from the provisions of Order 14 of the CPC. Under Order 14, the court, after from the frame the issues, after perusing the pleading, the affidavit, interrogatories, and affidavits. Similarly, a magistrate or a court of session frames charges, perusing the entire charge sheet, such as first information report under section 154 CRPC, statements recorded of various persons under section 161, statement under 162, statement under 164 by the magistrate, isn't it? All investigation conducted by the police officer. Because under the scheme of the police officer, which is our system is known as a adversarial system of law. In an adversarial system of law, the police officer collects evidence. He does the investigation. Whereas there is also another system which is known as inquisitorial trial, adversarial trial, inquisitorial trial, where the magistrate holds inquiries and gives direction to the police in what manner investigation must be conducted and report must be given. India के अंदर mostly we are following adversarial system of evidence. That is where the police officer is the main collection officer of evidence under the CRPC. And magistrate do not collect evidence. Magistrate do not do investigation. Whereas in countries like France and Germany and some of the countries, they follow the inquisitorial trial, namely, it is investigation is done only under the supervision of the court or magistrates. India there has been certain recommendation by the Mamalat Committee and Law Commission to amend the CRPC and Evidence Act to make it obligatory to have the inquisitorial trial system as is followed in France and Germany, where the learned magistrate, a judicial officer, directly participates in investigation. But India ke andar in CRPC, you know that here, when you see the definition of investigation, I want to produce to your attention. Investigation is essentially done by a police officer. An inquiry is done by the magistrate. Just kindly see section 2 of the CRPC, and I will tell you that investigation पे देख लीजिए आप. Section 2 H for Hyderabad. Investigation includes all proceeding under this code for the collection of evidence conducted by a police officer, please underline this, or by any person other than the magistrate. So magistrate is excluded from the domain of collecting of evidence. Who is authorized by magistrate in this behalf? So the learned magistrate, no sooner you make an application, you file a complaint under section 190 ABC CRPC, read with section 200. आप तो देख चुके होंगे. The learned magistrate, what he does, either he takes cognizance directly after verification, examining witnesses and document, or if he is not certain, he will say investigation by police. That order is passed under section 156.3 CRPC. But at the same time, section 200 may the learned magistrate states that inquiry is normally by the magistrate. Sometimes he may even start say investigation by private detective, that you have to make specific provision and make a prayer if you are an advocate for the parties. My lord, the police officer is biased. He knows the other side, local area, and I would request some retired commissioner of police, a retired detective may be employed, and you may suggest the name of your choice, a person, an agency who is expert. The court may consider. There is no bar. But the magistrate himself will not do investigation. Now see the inquiry who is done. See section section 2G, G for gold. Inquiry means every inquiry other than trial conducted under the code by the magistrate. So please bear in mind, under the scheme of our legal system in CRPC, criminal jurisprudence, the Magistrates do not do investigation. Only the police officer has been entrusted. So the powers start from the year from section 156 onwards, you know that, of the CRPC. And inquiry is contemplated in various sections, like section 200 maybe hai, section 145 maybe hai, 144 maybe hai. CRPC pade, I do not want to waste your time in that. So that is called the meaning of a adversarial system and a inquisitorial system. आप गूगल में जाके मारें वो मालूम पड़ेगा. So you are entitled to invoke the provisions of Evidence Act for giving evidence of fact in issue and relevant fact. So facts in issue are defined. Now, you please turn to the explanation to section 5. This section shall not enable up any person to give evidence of a fact which he is disentitled to prove by any provisions of law for the time being in force relating to civil procedure. This section shall not enable any person to give evidence of a fact which he is disentitled to prove by any provisions of law for the time being in force relating to civil procedure. Can anybody give me one example? CPC पढ़े आपने last term? याद आ रहा है?
Sir, ex parte decree.
नहीं. Ex parte decree. Not any person to give evidence of a fact which he is disentitled to prove by the provisions of law for the time being in force relating to civil procedure. What are the facts which you need not prove under the Code of Civil Procedure? You are not called upon to give evidence. एक भी नहीं याद आ रहा आपको भी? Under the Code of Civil Procedure, when you see the provisions of scheme order 10, order 11, order 12, order 13, उसके अंदर बताया गया आपको 12 के अंदर an admitted facts need not be proved. Decree court can pass admission. Then when you see the provisions of order 11, rule 19(2), you are prohibited from giving evidence of a document which is objected to. देख लीजिए आप जरा CPC, because yes. Order 11 खोल लीजिए. And first example will be order 7, rule 14. That I will start from there. The documents which you will not be permitted to give, will not be allowed to give evidence. Order 7, rule 14. देख लीजिए. A document which ought to be produced in court by plaintiff when the plaint is presented, annexed, but is not produced, shall not, without the leave of the court, be received in evidence on behalf of the party. That is one. You will not be allowed to tender it. Then order 8, rule 1A check कर लीजिए. Under order 8, rule A, also defendant who is not disclosed the documents to the court. Order 8, rule 1A, subclause 2, a document is in possession, power of a defendant, so and so. 3, a document which ought to be produced in court by the defendant under this rule is not produced, shall not, without the leave of the court, cannot be received in evidence. So you cannot give evidence here of this document because you are suppressed. Then another document which you cannot produce before the court of law is order privileged document also mentioned here under the provisions of yeah, दिखाता हूं आपको order 11. Point out the relevant yes, order 11, rule 19, clause 2, where on an application for an order for inspection privilege is claimed for any document, it shall be lawful for the court to inspect the document, deciding the validity of the claim, unless the document relates to a statement. The court may, on the application, party may at any time, so and so affidavit shall not have already been ordered, make the inquiry so and so. So these are these documents which specifically, and document where notice is given, you don't produce it. You cannot be permitted to withdraw. Is it? Protection of a document. The court passing order. See that order 11, rule 16 कहता है notice to produce. Time of the given. So these are the specific the documents where, despite giving notices, are documents which are privileged in nature, where you are not disclosed, you will not be allowed to use it in the evidence, and you cannot be permitted to give evidence. समझे ना आप? And there is a provision under order, the provision that order 13 check कर लीजिए आप. Order 13 also forbids you from giving evidence to certain facts. Evidence you cannot give. Order 13. Rule 3. Court may at any time reject document which considers irrelevant, otherwise inadmissible, recording of ground of rejection. So inadmissible evidence mean, for example, your agreement is unregistered. Now under section 59 of the Transfer of Property Act, your mortgage deed must be must be registered, must have been signed by 2 people. TP Act पढ़ लीजिए आप उधर. So section 49 forbids you from using that document in the court of law. अगर आप ट्रांसफर ऑफ प्रॉपर्टी एक्ट भी चेक कर लें इसके अंदर, this is related to the document section 59, not relevant if I'm not mistaken. Yes, mortgage when to be assurance. When the principal money secured is a 100 rupees upwards mortgage, other than the mortgage by deposit of title deed, can be effected only by registered instrument signed by the mortgagor and attested by lease or 2 witnesses. Where the principal money. Now, mortgage suits are filed under the provisions of Order 34 of the Code of Civil Procedure. आपने पढ़ चुके हैं CPC में. Please open your, remember this, all this section. Order 34 may, when you are filing a suit for redemption of a mortgage or for foreclosure of a mortgage, 34 में पढ़े suit relating to mortgages of immovable property. So when you produce a document which is unregistered, it will not be admissible. Under the provisions of Order 13, Rule 2, read with the Section 49 of the Registration Act. आपके पास Registration Act है तो उधर पढ़ लीजिए, because it section the Registration Act section 1617 makes it compulsory to register document. Isn't it? सेक्शन 17 मेक्स इट कंपल्सरी, तो वो सेक्शन 13 से कनेक्टेड है सीपीसी के अंदर। तो सेक्शन 49 of the registration act tells you effect of non-registration. ये remember करना आप, because you will have to remember this, how they are connected. See, effect of non-registration of a document required by registration. No document required by section 17 of the provisions of the Transfer of Property Act to be registered shall be affect any immovable property be received in evidence of any transaction. So इसीलिए section order 13 rule 1 and 2 CPC subclause 3 bars you from producing the document. So yeah, that is how you connect this to the various provisions of Law Evidence Act. Please note that. So इसीलिए whatever you read last year, not to forget. हाँ, याद रखिए जरा, थोड़ा recapitulate your memory. Next. Now illustration check करें, मालूम पड़ेगा अभी. Though they are used is CPC, illustration दिए यहाँ पे criminal code के, no problem. Both are CPC, CRPC, or both are procedural laws. We can deal with it. A is tried for the murder of B by beating him with club with intention of causing his death. तो यहाँ पे culpable homicide amounting to murder हो गया है. Section 300, 302 of the Indian Penal Code पढ़ चुके हैं आप. A is tried for murder of B by beating him with a club with the intention of causing his death. Intention mens rea है इसके ऊपर, जानबूझ के इसने मारा है. At A's trial, the following facts are an issue. Or they are an issue, they are, I mean, at the time of framing of a charges, the magistrate, the session judge will consider number one. A is beating B with the club. So at the trial, the prosecution has to prove what? A has committed the murder of B. Number one, वो club कहाँ से लेके आए? So normally during investigation, police officer will recover under 27. एक club पकड़ेगा उसको उसमें. Of course, confession not admissible, मैंने murder किया है. But discovery and recovery of article under section 27 of the Evidence Act is permissible. तो एक club को लिखाना पड़ेगा. और dead body को भी produce करना पड़ेगा. Body कहाँ फेंका आपने? Unless you prove dead body before the court of law, there is a suspicion in the court, murder ही नहीं हुआ है. पहले dead body, bring the corpse before the court. That is the normal criteria before the criminal court. And how the death was caused, number one, एक club से लेके आओ. ये जो instrument है, weapon should be produced. ये कहाँ से खरीदा था? From where did he purchase it? Number two, of course, three will be evidence will be under the provisions of his intention, his mind, bodily feeling, mens rea, वो सब चीजें बाद में आएंगे. पहले ये चीज तो प्रोड्यूस कर लिए. दो हो गए. Number three, A's intention to cause B's death. So intention mens rea is important. Why is he attacked him? There may be a reason. There was a provocation, or the A has been dispossessed in a civil suit filed by B for dispossession, and a decree is passed. He is frustrated. उसको जाके attack कर दिया. It can, that is the reason. Or A will take up the plea that year. Maybe I was unsound mind, or I found him in a compromising position with my wife. That can be a defense. That is the reason that gave him the reason for killing him. That is the intention. That is the mens rea. Then see, these are the things which will be an issue before the court. So that is how under section 211 of the CRPC 200 आपने पढ़ा है इसके अंदर. When charges are framed, so don't get confused के issues are nothing but charges in criminal court. So they are also called issues. Sometimes the criminal court also, instead of using accused, they use the word defendant. In America, the accused person is used as a defendant. Now next example दीजिए. A suitor does not bring with him and have in readiness for production the first hearing of the case a bond which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceeding, otherwise than in accordance with the condition prescribed in the Code of Civil Procedure. तो सिविल प्रोसीजर में अभी पढ़े हमने, if the plaintiff does not disclose his document in the plain under Order 7, Rule 14, Sub-Rule 3 forbids him to giving the document in evidence. Similarly, if a defendant does not disclose the document and does not take the leave of the court, he will not be permitted to give evidence on the document. Similarly, under the provisions of Order 14, Order 11, Rule 1415, the court directs him to give inspection, and under Order 11 directs him to give interrogatories. He doesn't answer, he will not be permitted to rely upon. Similarly, under Order 11, Rule 13, he is directed to file affidavit of document. He does not do so. अगर नहीं करेगा, you are not supposed to take the other side by surprise. That is why it tells you. I will just close it. I'm sorry. Just close it. Give me 1 minute. I'll close the fan. Yes. So, in our adversarial system, ours is an Anglo-Saxon trial where nobody can be taken by surprise. In order to meet the case of each other, that is why under the provisions of Order 16, Rule 16, it mandates that all parties must exchange their list of the witnesses. Why you are required to exchange the list of witnesses? The other party has a right to make inquiries about your witnesses. Whether they are good witnesses, bad witnesses, whether they are respectable people, whether they are criminals having any antecedent. So the other party can make investigation in the court of law or some police station, whether he is implicated in any cases. How is he related to the plaintiff or defendant? ये सब inquiry करने के लिए. Because during the cross-examination, you have a right to put to him questions to impeach his credibility under Section 146 and 155 of the Evidence Act. That is the reason why you are made to tell, you are told that here you must give inspection of all the document. The CPC bars you completely if you don't disclose the document, or document which are not disclosed subsequently, you must seek permission of the court that I may be allowed to tender now only when permission is given. Otherwise, document nahi prove karne denge. Understood this section 5? That is the meaning of section 5, where when at the time when issues are framed, on or before. So the explanation का मतलब ये हुआ, the documents which are in your possession, you must give the other side copies. Of course, there is one special saving clause in that. There is an inbuilt safeguard against you. The document which you want to cross-examine the other side. I mean, those may be the document written by the other side to you, admitting liability or maybe making some contradictory stand. So those documents you need not disclose. A document meant for impeaching the credibility, which you can be used under Section 145 of the Evidence Act. I have discussed this point with you both while dealing with CPC, CRPC, as well as now I'm dealing with it. Please remember this. That is the only document. Otherwise, all your document, your witnesses document to prove your case, in order to prove, the court will see all matters before the court. Inspection must be given. अगर आप document कोई भी withhold करे, CPC doesn't permit it. So the only privilege you enjoy is not to disclose a document which you can use for cross-examination of the other side. For example, in an adultery case, the husband must have written some love letter to his paramour. The wife need not, उसके हाथ में आ गया हो. She need not disclose it at this stage to him. She will use it as a weapon. Similarly, a landlord has come into possession some properties purchased by the tenant, new houses in the name of tenant on his family members, and suit may be filed for bona fide requirement. Tenant will take up the plea, मेरे पास एक ही घर है, कोई और नहीं है. But the landlord has made inquiries. Tenant is a rich man, बच्चे लोग कमा रहे हैं, गमा रहे हैं, 5-6 प्रॉपर्टी खरीद रहे हैं. Those documents of the defendant you need not disclose in the plain or written. You can only disclose to him in cross-examination. You can impeach the credibility. You may ask him, gentlemen, please tell the honorable court, apart from the tenanted premises, what are your other premises you have any? वो बोलेगा मेरे पास कुछ भी नहीं है और I do not have. I'm a poor man. I don't have. Then you may ask him question. Do you have? Are you a member of a flat in so and so society? He may deny it. You must have collected, registered. Please look here at the conveyance deed on agreement of sale between you and Mr. X where you have purchased. He will rattle how you got it. That is immaterial. Huh? So your statement before the court that you do not have the premises is correct, or the statement that you are registered owner of a flat is correct. That means you are contradicting him. You are proving before the court of law that he is a liar. Okay, so that's a document you need not. Similarly, your husband and wife, if they are proving a ground of adultery, they need not disclose the letter. Of course, they may be joining the adulterer as a party. They will deny adultery is a secret crime. कौन admit करेगा? Isn't it? Adultery as a criminal case has been decriminalized, but for a civil cases it is all goods. For divorce के लिए and claiming damages it is good. So you may use it here. Look here. Have you ever? Do you know the gentleman for how many years? At any time did you correspond with him? कोई letter लिखे आपने? नहीं. Look here. This letter in your handwriting. Do you recognize your writing? पकड़ेंगे आप because you will have, then you can ask, request the court, my lord, may I ask her to sign before the court. Take some sample of her signatures. Court can compare the handwriting under section 73 of the Evidence Act. You can ask an accused person, other side, to give the signature. You can tell the court her signatures and writing may be compared in the Wakalatnama and in the places she has written other letters, admitted letters. You can catch hold of them. So he or she can definitely do that. Those documents need not be used. तो इसका मतलब यही हुआ. So the Evidence Act permits you to lead evidence in respect of matters where the issues are framed under the provisions of Order 14. I won't again read Order 14. Then charges which have been framed by the criminal code under the provisions of section 211 say onwards. Please note that here. So you don't you know that is the chapter number 17 in CRPC. 211 contents of charges, when manner of charging, particulars of charges. Yeah, these are all issues in a criminal code. Please note that here. They are the issues till section 211 से लेकर 237 तक. And they are same in court in the provisions of Order 14. Yeah. So you understood this? You are supposed to give evidence only relating to fact and issue. And secondly, you are permitted to also give evidence of relevant facts. I mean, only two types of facts you give in evidence. Fact and issues which are covered under Order 14 and Chapter 17 in CRPC. And not beyond that. And further, you are permitted, given liberty, to prove the add to the fact and issue relevant fact. Relevant facts are starting from section 6 onwards. Section 6 onward, Lily ji, this is it opens a Pandora box of litigation, of evidence, nature of evidence, various types of evidence required to be given. I will connect each section with the other connecting section. As far as possible, we'll take it. I'll explain to you. तो अभी आपने सेक्शन 5 चेक कर लिए. अभी सेक्शन 5 को हमने कनेक्ट किया with order provisions of order 7 rule 14, order 8 rule 1A, then order 11, order 13 CPC के अंदर, then order 11 rule 19 sub clause 2 privilege document. ये सब चीजें याद रखिए आप. So they are connected to this. Then in CRPC के अंदर the chapter 17 starting from section 211 onwards. Yes. Now the second branch of evidence which you are permitted to lead during a trial is starting from relevant facts commencing from section 6, because even a judge, only the parties are required to ask in a court of law examination chief cross examination may only on fact in issue and relevant fact and not beyond. But the learned judge or a magistrate under the provisions of section 165, he has a right to ask questions which are relevant or irrelevant. But the proviso to 165 says that though the judge has got the privilege to ask questions which are relevant, irrelevant, but his judgment must be based upon facts which are declared to be relevant and duly proved. That means he cannot travel beyond the judgment. He cannot be given on bizarre facts which are unconnected. Though they may be material, unconnected material, he has to discard it. Now, section 6 पे आ जाइए. Section 6 is also known as the rule of res gestae. Those of you will be reading the commentary. वो पढ़ लीजिए आप. Res gestae करके, that the American RES dash GESTAE, res gestae. It's an English doctrine. Res gestae rule. Res gestae rule का मतलब क्या होता है? How the normally the evidence given by a person who has heard something from third person is normally not admissible. उसको बोलते हैं hearsay rule. क्या बोलते हैं? Hearsay evidence, or it is also called a derivative evidence. I mean, the evidence is derived from third party is normally not admissible because section 59 tells you of the Evidence Act, evidence must be direct. पढ़े ना आपने? दोबारा देख लीजिए आप. Section 60 tells you oral evidence must be direct. It refers to a person who has seen it or who heard it, who perceived it. Section 60 याद कीजिए आप. So direct evidence, this is also known as a best evidence rule. But normally, as a general rule, a hearsay evidence, तीसरे आदमी से, my friend Ram told me Sham has attacked so and so. It is not admissible, basically. But there are certain sections, including section 6, permits the hearsay evidence. Now let us see that res gestae rule क्या होता है. ये illustration पढ़ेंगे समझ में आ जाएगा. And section, see the thing. Relevancy of fact forming part of the same transaction. Underline the word. Relevancy of facts forming part of the same transaction. So the fact is connected with the other fact having the same transaction. Let us see. Fact which though not in issue. यहाँ पे देखिए section 5 कहता है facts must be in issue. Now this makes a departure here. Facts though not in issue. The court is not bound to frame issue of a non-issue of a particular fact. You are seeking declaration that you are a owner of A property. So they cannot be issue with regard to C, E, F property, isn't it? The court is not concerned, but sometime it becomes relevant. Now let us see. Facts which though not in issue are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at a different time and place. So यहाँ पे connection of two types of fact, they may be independent facts, but they are forming part of the same transaction, but they are nexus to each other. An inference can be drawn कि ये fact जो conspiracy मुंबई में हुई है, it is related to something which happened in Karachi or in Dubai. It is connected as an account of it, some offense has taken place. तो यहाँ पे facts in Mumbai at Churchgate में जो हुआ है, and whether it is relevant in government law college or some other place, and being spoken by people who have not directly seen the offense but heard it from someone who were the parties. So you as a government law college student took a train from Churchgate, from your place, maybe Andheri, Bandra or Borivali, up Churchgate में उतरे. You saw a commotion of 100 people shouting, ये उसने मार दिया, मर गया, मर गया. You just heard it, the outcry, but you are not seen कौन किसको मारा. Huh? Commotion here के मर गया, खून बह गया, you know. And he gave up, he died. आवाजें सुने आपने. So you just ran, and immediately, as a very conscientious student of the government law college, you went to the police station and lodged a complaint. I heard some cries, some people was sitting shouting कि मर गया, वहां पे death हो गया. So whether your statement, even my friend was shouting there, who went ahead of me कि उसने मार दिया. Whether the shouting of your friend, shouting of the 10 people who were made a commotion, whether you just heard it, of course, you have not seen the offense. कौन किसको मारा? वो आपकी बयानी, is it valid? Let us see this example. That is a illustration. A is accused of murder of B by beating him. A is accused of murder of B by beating him. Whatever was said or done by A or by B, तो दोनों में whatever conversation took place. Why I am hitting you? This reason. B reason. You stole my watch. You stole my ganam. Whatever mobile phone. You had an evil eye over my sister or my brother or my wife. Huh? You grab my property. I am not going to leave you. I will teach you a lesson. ये चीज बात है नहीं, मैंने नहीं किया, उसने बोलेगा I not done it. Huh? I did it because somebody instigated me. Otherwise, I would not have done it. I'm so sorry. It has happened inadvertently, not true. Also, I did not do intentionally. ये दोनों के conversation चल रहे हैं. Then, or by the bystanders. So some people are watching this tamasha. So what is happening? What is being conversed between the conversation between A and B? A is being attacked by B or B is being attacked by A. दोनों में जो गुफ्तगू हो रही है, the heated exchanges are being heard by people like you and me, who just got down from the train, who got down from the bus stop, who were just standing. We are the standbys. We are the bystanders or the spectators at the beating, or shortly before, or after it, as to form the part of the transaction are relevant. So the very fact that you were present at the time, you got down from a fast train which you took from Virar, and you reached the Churchgate station to attend to your college student lectures 7:30 in the morning, and you are present there. So you can prove that you are a student, you are present, you are holding a valid pass, and you have a bona fide certificate or identification card of the college. So nobody can dispute that you're present, number one. And you heard the commotion between A and B, who were shouting, who were ranting and raving and indulging in violence. And you were a party to that. And apart from you, there were a mob of 25 people are collected. So you heard the shoutings of these two people, or the people who were saying, yes, he's hitting him for this reason. A is uttering this, B is uttering that. So these are all being echoed. ये दूसरों की आवाज में आ रही है. So that is, if that is so, though they are conversation and talk between two people, and you are a bystander, you watched it or you heard it from either from A or B or from the bystander. It is not necessary you should have heard from A and B. Even the bystander, बाहर आके निकले बोले देखिए वो ए ने मारा बी को, ये बोल रहा था ये रीजन उसकी प्रॉपर्टी छीन लिया उसने, उसका गोल्ड चेन छीन लिया, उसकी बीवी से कुछ चक्कर था उसके साथ में. All these statements you heard it. So you can be an informer. You can lodge a first information report under 154. Please note that. Any Tom, Dick, and Harry under the CRPC, the doctrine of locus standi is very wide. That is the meaning here. Huh? Unlike the civil law, you must have a cause of action. You must be interested person. In CRPC के अंदर many of the offences, you need not be a person who is in, who is an injured person or you are not an agreed person. You are an informer. You can be informer. You are a person who has knowledge about it. You heard it. In fact, CRPC mandates you. If somebody commits a crime in your prison, you are bound to get him arrested and take him to police. Otherwise, you can be arrested. पढ़े ना आपने? Section 37, 37 is onward apart. Okay. So this section makes a departure now. See that. Section 6, that means a window is kept open for a third party's conversation to be taken on record, which can be deposed by you in the court of law. Yeah, that is illustration A. Illustration B, that is the murder case. Now see, A is accused of waging a war against the government of India. Waging a war against India is a very serious crime, isn't it? By taking part in an armed insurrection in which property is destroyed, troops are attacked, and goals are broken open, the occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present, all of them. Now, our country is having tension with China and Pakistan, isn't it? Now, there are allegations that the Chinese have been encroaching upon various territories, goals, the troops have been exchanging war, वहां पे बिल्डिंग और डैमेज हो चुके हैं, isn't it? So here, the neighboring occupiers, in case a local commission is set up or matter is required to be tried, or whatever maybe, some action is to be taken to prove a particular war has taken place or not. Yes, of goals, troops attacks, goals attacks, occurrences had taken place, forming their part of the same transaction. They are admissible in the court of law as res geste statements. Okay, so they may not be direct evidence. So these are the evidence coming from other sources, from circumstantial evidence. These are all circumstances will tell you. Witnesses may lie, documents may lie, circumstances will not lie. Something has been uprooted. You may take up the plea that here A, I could not fulfill the contract of A in getting the transportation in time and paying the bouquet because there was a war between India and China or Pakistan. and I was interrupted. Transportation was caused. So the A may file a suit for recovery of 1 crore damages on account of non-delivery in time. ये हो चुका. B will take up the plea. There was a frustration of a contract. There was a war going on between India and China, India and Pakistan, and as a result, troops were uh, scattered around. Transportation बंद हो गया, and I could not deliver in time. Isn't it? It's a good defense for the party who could not defend. So you learned under the Indian Contract Act, there is a doctrine called a frustration of a contract, which is under section 56. जब कोई कलामटी आ जाती है, जब कोई war हो जाता है, some unable to perform for A reason, B reason, that evidence is good. So you have to prove these things have happened. The troops have destroyed, a war ho gaya, circumstances, and I could not perform my contract. That evidence is admissible before the court of law. So you may play before the court of law a video after having obtained a certificate under 65A or B of the Evidence Act. Yes, this is the connect event. Okay, illustration A and B with regard to proving res geste statement. Number 3 पे आ जाइए. A and B dealt with the criminal cases where you can take a plea of alibi, where you can bring the evidence with regard to third parties. A के अंदर, समझे ना? The murder of B, bystander evidence. So hearsay evidence becomes admissible here under the provisions of section 6, illustration A. Now illustration B के अंदर, this can be used to prove that here I was prevented from doing this act on account of this destruction which took place. That evidence can be let. Puri history, geography of the cyclone, the war, troops is on record before the court. See, the court, court can take a judicial notice of the fact under the provisions of the Evidence Act, section 56, 57. कहता है कि court can take judicial notice that Ganges is flowing from this direction. Court will take a judicial notice, isn't it? The Calcutta, the river is flowing in that direction, or the mountain is moving in that direction, situate in that direction. The shipwreck has caused so much havoc in a particular ocean. So these are the examples with regard to that here. Now let us see. C covers some of the civil cases, res geste statement, how in a civil litigation you can prove it here. A sues B for libel containing in a letter forming part of the correspondence. Letters between the parties relating to the subject out of which libel arose are forming part of the correspondence in which it contained are relevant fact, though they do not contain the libel itself. A and B are businessmen. A is from Mumbai, another from B is from Calcutta or Delhi, let us take for example. A has a factory and B is a manufacturer of certain chemicals. I need the chemical, I am placing order for 1 crore rupees tonnage. Please send it within a period of 15 days time or 1 month's time. Time is the essence of a contract. Correspondence, yes, I shall produce it, I shall send it, money is sent. 50% advance amount is sent, remaining amount will be given. अभी ए एंड बी के करस्पॉन्डेंस एक कमर्शियल लेवल पे चल रहे थे शुरुआत में, इंट्रोडक्शन अच्छा चल रहा था, बट कुछ डिले हो गया, inferior क्वालिटी ऑफ मटेरियल आ गया, एज ए रिजल्ट वेयर ऑफ कस्टमर रिजेक्ट्स योर गुड्स इन बॉम्बे. सो दिल्ली वाले को आप यू राइट ए वेरी हार्श लेटर कि यू आर नॉट ए बिजनेसमैन, यू आर ए हजाम. So this kind of gali galoch is not permitted, isn't it? You cannot be indulging in a campaign of vilification. I lost my contract worth 50 crores because of your because of your defective articles. I am going to sue you for this. You people do not know. Better you become barbers. So this kind of vilification and CC is sent to the customers. So merely if A writes to B is not defamation liable. But if a CC is sent to third parties, it's a defamation, isn't it? A third party has come to know. He is trying to justify his own customer. He has rejected the mal and he could not give it because the gentleman, he doesn't know and he has abused him. Gali galoch kiye. So in the court of law, at the time when the gentleman from Delhi, files a suit for defamation or a criminal complaint or claims damages on the ground that you have defamed him, you abused him, and you, under section 73 of the Indian Contract Act, you claim damages. And you may also resort to proceeding under section 499, 500, 502 of the Indian Penal Code, which go before the magistrate. And suit for damages, they go before the civil court, a district court, or the high court, original side, depending upon the valuation. So at the time when you lead evidence before the court of law, so you will produce before the court the letters of introduction between both of you. I run a factory, the defendant manufactures, so I was in need here. We have been doing business. I was introduced by ABC, and these are the letters, and I dispatched material. I paid him money consideration. But in the middle of nowhere, out of material which was sent was defective, and I lost my control and I did it. So the other side will take up the plea. These are highly defamatory. And these letters he has forwarded to police authorities. His own clients and customers, he has defamed me. And he has threatened me that I will blacklist you with the government of India authorities. So these are all serious allegations. These have defamed me. And as a result, I suffered substantial losses. So the letters you are introducing before the court of law, defamation, and the earlier letter, connecting letter you are producing, third letters. So though they may not be the earlier letter where the promises took place to pay and money, they may not be relevant for defamation. But they are connected in such a manner to show that how the parties' relationship came into existence. That is why the earlier letters become facts forming the part of the same transaction which the letters which constituted defamation. समझे ना आप? So the other side cannot take up the plea. They are not relevant. They may not be produced. Why not? They are relevant because I had to establish before the court of law the defamation took place in this context. The to explain the introduction of the parties. Introductory facts are required to be proved by leading evidence of our earlier correspondence. So not only section 6 permits me to lead these forming the transaction, even section 9 of the Evidence Act, just open facts necessary to explain and introduce relevant fact. Just open section 9. Fact necessary to explain or introduce fact in issue relevant fact with support or rebut inference suggested by fact in issue relevant fact establish the identity of anything person identity is relevant or fix the time place which may be an issue. So you cannot be shut. Other side cannot tell you those facts are not relevant, don't introduce. No, they are relevant. What the other parties, what the gentleman, because you have a right to even show the court the letters written by the customers of A to whom he could not in time deliver the goods because on account of the mistake of B. So A के customer कौन XYZ. My lord, the letters of XYZ are relevant because they are threatening to take me to court of law. I have to pay them damages on account of the inferior quality. So these are relevant correspondence. I have a right to explain the nature of the transaction. So they are forming part of the same transaction. So the documents may kindly be taken on record and admitted. समझे ना आप? दो थर्ड पार्टी के लेटर हैं ये. They are not directly in issue before the court. The issue before the court is defamation A committing defamation of B, a libel of B. How the letter of XYZ is relevant? They become relevant for the purpose of section 6 and section 9 to explain the identity, to introduce the facts, to explain the necessary facts. समझे ना आप? Have you understood this? समझ में आया कुमार? नहीं आ रहा है? आशुतोष समझ में आ रहा नहीं? I'm not hearing from anybody.
Got it.
हाँ जी, is okay.
Yes, sir.
Yes, जवाब दीजिए. Interact with me, then I don't go to sleep. Yeah, that is how
Sure,
the yeah. बीच में बोलते जाइए. Yes, I will. Yeah, yes, connection. Yes. Now next illustration check कर लीजिए आप. The question is whether certain goods ordered from B were delivered. The question is whether certain goods ordered from B were delivered to A. ये delivery of goods के बारे में. The goods were delivered to several intermediate persons successively. Each delivery is relevant. So transportation के अंदर आपने माल भेजा दिल्ली से लेकर बैंगलोर. So the transporter is not just sending your material, is collecting of various parties. हाँ? तो दिल्ली में अजमेर भी आ गया, आपका अहमदाबाद भी आ गया, बॉम्बे भी आ गया, बीच में सबको 15, 20, 50 कस्टमर का माल डाल के जाते हुए गए. So you wrote a letter to the transporter कि my goods are missing. Huh? They are stolen. They are not delivered in time. So the transporters can take up the plea that here, or he may even take up the plea आपका delay भी हो गया. बोले कि in a transaction like this where I am delivering several people's articles, some delay can cause. It's human error. And your contention that it is not delivered or delivered, or they may have been mixed. I'm not saying no. There are several deliveries to several customers. I will find out from them. So when the matter goes to the court of law, both the parties will be permitted to lead evidence of third parties here, who they are not connected to the issue with regard to delivery of A to B. So there may be delivery to B, X, Y, Z. कितने लोगों को दिया होगा? So each successive deliveries, you have a right to examine them as witnesses, getting the list here to check, find out what happened. Whether the contention is correct or not, whether he acted transporter, whether act bona fide. So though the entries, though the deliveries which the transporter has effected upon the other customer is technically not relevant to you, but they are forming part of the same transaction when you sued them claiming a deficiency of service, or when you claim damages, or when you said that your accident has ho gaya, mal mix ho gaya. Many things come across, many such matters are there before the court of. So you are permitted to examine the other people, other transaction, and place before the court of law, though they are not connected to your matter. They are not relevant, but they are forming the part of the same transaction because they went from the same route, in the same transportation. The list is prepared. The list is given to everybody. So and so Patel Railways or railway transaction, goods services, or many of the ये आजकल न्यूज़पेपर में पढ़ते हैं आप, heavy में we carry the materials, goods in a good condition. So when an issue goes to the court of law, you have a right to examine each and everybody. So the evidence become relevant. So this is called evidence, though not relevant, though it is not a fact in issue connected to your matter, but it is forming part of the same transaction. You can examine a lorry driver, you can examine the cleaner. क्या हुआ क्या नहीं हुआ, reason क्या हुआ, कहाँ mix हो गया. So though drivers and cleaners are not responsible for you deal with the master, the transporter. Under the law, but you have a right to examine them to find out the veracity. What happened? Why delivery did not take place? Where the kisko deliver kiye material? Huh? Your good quality material is mixed up with other people's material, and your good quality is gone to somebody else. So you may appoint commissioners from the court of law, the commissioner to take inspection, see the document. Commissioner's report, commissioner is appointed to 3-4 places. Inspection is taken. So these are all may not be evidence, it will be a matter before the court when you seek to prove before the court, not just a fact in issue, but the connected facts forming the part of the same transaction. Though not in issue with your matter, they are matters related to the same transaction. Anybody want to ask me question? पूछ लीजिए. ये section 6 हो गया. Anybody has any doubts?
Sir, I have a doubt.
Future.
Sir, what exactly is the difference between res geste and hearsay?
Hearsay is something where a third party conveys to you. You heard third party saying something. When actually A has not heard it, he has not seen it. Section 60 of the Evidence Act mandates that direct evidence means a person who has seen with his own eyes or heard from his own ears or perceived with his own senses. और ये तीनों मिस हैं. और ये कहता है कि I was present, I gave you example, I was present at Churchgate station and I heard the cries of the gentleman. People were shouting. Or you take other example. Husband and wife are quarreling. Viciously quarreling. There is a domestic violence. Small 2 children, aged 5 and 3, are shouting. Ke mera baap, my father is strangulating the mother, my mother's head. And he has lit fire. You as an immediate neighbor, you heard the shoutings of your boy and the girl. Of course, you have not seen strangulation. हो बेड के ऊपर कर रहा है. मेरा बाप ने मेरी माँ को गला दबा रहा है, दबा दिया, दबा दिया. बच्चे लोग शाउट कर रहे हैं. That is hearsay. Hearsay, but it is res geste, relevant. Did you understand this? You being an immediate neighbor, your evidence will be accepted apart from examining the child. You say that I am the immediate neighbor of Mr. X. His wife was dead and the prosecution has been filed that the husband killed it. And I heard this statement. I heard the cries of the child, boy, both the girl and boy. मेरे बाप ने मेरे माँ का गला दबा रहा है और उसको मार दिया. Though I have not seen it, but I heard it. But the fact that the mother is dead. So it is the fact that it is a forming part of the same transaction. You are a person who heard the cries, your evidence is relevant. Though you are a person who has not personally seen it. So this is a departure to the third party's evidence, a person who has not derivative evidence. Actually, it's a hearsay evidence, but it's a hearsay evidence forming part of the same transaction, becoming relevant. It becomes a believable evidence. अभी समझ में आया नहीं आपको? इलस्ट्रेशन दोबारा पढ़िए आप ये. Illustration A, B, C, D पढ़ेंगे. Read again, go home 3-4 times. You will understand this. And what I said, I gave you illustration of Churchgate Station का, वो याद रखिए. And right now I gave you son and the children shouting, ranting and raving in a chawl that my father is strangulating my mother, she died. And you are a neighbor who has not seen it, you heard the cries. And you are reporting your information, you will be a good witness. So that res geste statement, it is res geste statement, is admissible under section 6. समझ में आया नहीं अभी?
Yes, sir. So, sir, I have one more query in extension to what you said. So, let's say I am the woman who heard the children crying, and because of fear of that man, I do not say anything to the police, but I say it to my friend. So that friend cannot use that statement that we had conversed in confidential and use it in the court, can he?
If the police officer examines your friends and also records your statement under 161, then examines you as a witness in the court, both of you are called corroborative witnesses. क्या बोलते हैं? क्या बोलते हैं? Corroborative evidence, which is permissible under the provisions of section 156 Kolia. Question tending to corroborate evidence of relevant fact admissible. See how Evidence Act is connecting. In rape cases, generally a girl is very afraid of telling the truth to anybody. 1 महीना 2 महीने 3 महीने नहीं बोलेगी शर्म के मारे, because in Indian condition a woman is told that sex is something very sin. She doesn't want to be disgraced. She feels that she will be humiliated और लोग उसको बुरी नजर से देखेंगे. And she confides it to you as a best friend. You may go and tell her mother. Her mother goes and lodge FIR. And you will also be examined along with the mother as a corroborative piece of evidence. Then evidence becomes admissible. Evidence Act is a act which will not leave anybody. It will try to elicit evidence from any sources. The evidence doesn't become bad because it is coming from third party, fourth party. But if it is forming the part of the same transaction, the prosecution must lead evidence to show that, prove that here, the evidence, your evidence, which you initially suppress, would not say you had no courage to go to police, but you inform her mother that your daughter has been outraged, your daughter has been a victim of rape, and she lodges FIR, and how she got the information, police will record, she will be the first informer, and you will be a corroborative evidence witness. Your evidence will be definitely good evidence under section 6, and you can be used under section 156 of the Evidence Act. So you are corroborating what the mother stated, and the girl has been examined, DNA test prove that yes, sexual assault hua hai. So these are all corroborating. So if the DNA test is establishing that girl has been, uska vagina has been pierced, a tender age girl, maybe 14 years old, she was bleeding, she could not say out of fear. So medical reports are corroborating your evidence. So you will be a good witness. समझे ना आप? समझ में आ गया?
Yes, sir.
Yes. What is your name?
Bhavya Banerjee.
Thabria.
Bhavya.
I don't see your name here. Bhavya, yes, I could see BV. Yeah, anybody has any more question? We will take section 7 also now today. Then 7 के बाद बंद करेंगे. Then we'll go further because let us go step by step. I am connecting it to you. Shall I proceed to 7? Or anybody has any question in 6? Shall we proceed to 7? No. You do not want to permit me to go to 7?
Yes, sir.
Yes.
We can go to 7.
Yes, please so. This is a very interesting section. I mean, this is also relevant facts. 6 से लेकर 55 तक relevant facts हैं. How the relevant facts? Facts which are the occasion. Underline this word. यहाँ पे कितने 4? यहाँ पे पहले 6 के अंदर एक ही फैक्ट इन्वॉल्व है. तो यहाँ पे दिया था 3-4 फैक्ट इन्वॉल्व. Facts which are the occasion, number 1. Then facts which are the cause, number 2. Then facts which are the effect, number 3. Immediate or otherwise. देखो 3 टाइप ऑफ फैक्ट्स को बोलता है. Facts which are the occasion, cause or effect. Immediate, otherwise. Mean it may be immediate or remote. Of the relevant fact or fact in issue. तो यहाँ पे 7 is embracing little more further. 6 is only saying connected with the fact in issue, but 7 says relevant to the fact in issue, which is otherwise of the facts of the relevant fact or fact in issue. दोनों को शामिल किया है. Mean other connected facts. So, like I gave you, you heard it from the girl. An offense was committed. You did not lodge FIR. You went and told the mother. Mother lodges it. तो यहाँ पे ये cause and effect में आता है. Let us see. Which constitute the state of things under which they happen, or which afforded an opportunity for their occurrence or transaction or relevant. So, these 3 types of facts, which are the occasion, cause, and effect, which may be immediately or otherwise connected to fact in issue or relevant fact. Constituting state of thing, mean what is there in your mind? What is there in your heart? What is the mens rea? And how they happen? And what was the reason, opportunity for happening, for occurrences, are relevant. So यहाँ पे the dragnet is still further open किया गया है. More scope is given for accepting evidence in a very liberal manner, not in a rigid manner. Now please read the illustration. इसमें समझ में आएगा आपको. Number 1. The question is whether A rob B. ये robbery का केस है 392-94 में आता है इधर. The fact that shortly before robbery, B went to a fair with money in his possession. So he is the victim. So B went to a fair, maybe some kind of what is a fair? The Bombay के अंदर famously known as Mount Mary Fair, और some temple में जो होता है जागरण fair, और इलाहाबाद में होता है what is every 4 year के बाद क्या होता है वो? What it is called?
कुंभ मेला सर.
कुंभ मेला. कुंभ मेला हो रहा है. कुंभ मेले में गया पैसे जेब में डाल के, because it's a festival occasion. You like to enjoy. So the fact that before the robbery, so B was knowing you are carrying money, went to fair with money in possession, and that he showed it. आपने 100 रुपये 2000 रुपये के नोट सबको बताया आपके फ्रेंड लोग को. So you are a son of a very influential father, a politician or a builder. देखिए भाई, you want to impress your friend or girlfriends, whoever may be. देखिए मेरे पास 2 बंडल 4 बंडल हैं, खर्चा करेंगे. So आपके पीछे मिस्टर ए इज कीपिंग ए वॉच ऑन यू. अरे इसके पास तो बहुत पैसे हैं. हाँ, एंड यू आर बोस्टिंग अबाउट इट. द जेंटलमैन बी वाज बोस्टिंग, देखिए मेरे पास तो 1 लाख रुपया है उड़ाने के लिए, हाँ, ऐश करने के लिए. एंड द फैक्ट दैट ही हैड इट, and the fact that he had it to third persons are relevant. So he was telling it to everybody, his friends, X, Y, Z, or even to shopkeepers. Bargain कर रहा है, भाई तेरे पास तो पैसा नहीं, why you want to come and do bargaining? अरे भाई ऐसा क्यों बोलते हो तुम? I am a son of a rich man. You are a young person, 20s में, आपको पास ज्यादा अग्रेशन होता है इस टाइम पे, enthusiasm. Don't call me a कड़का. See, look here, मेरे पास 10 लाख रुपए लाया हूं, मैं 1 लाख रुपए लाया हूं. So I heard his conversation. So your conversation with the shopkeeper who called you kadka, क्यों आप bargain करते हो? जेब में पैसा नहीं रहेगा तो नहीं, बोले look here, मेरे पास पैसा है. So I am a thief, I am keeping watch. मैं सुना आपकी dialogue between them, isn't it? And even the other people who heard it. So that is the occasion. So you had the occasion to show that you are a rich man, you have money. So वो occasion में जो भी लोग मौजूद थे, though they are not relevant, that their evidence becomes, is it my phone or somebody else ringing? Somebody's phone ringing, देख लीजिए. Okay. मेरा तो नहीं ना? Is it mine or somebody else, please?
Sir, it's yours only.
हाँ, मैं बंद कर देता हूँ अभी से. I will put off my phone because people like to bother me this time. या फोन ही बंद कर दिया मैं. ना रही बांस ना रही बांसुरी. चलिए, तो यहाँ पे थर्ड पार्टी हु हर्ड दैट यू आर हैविंग मनी, आपने मेले के अंदर बड़े जोश और खरोश से अनाउंस किया मेरे पास पैसा है, तो इज रेलेवेंट फैक्ट. ओके, देन द क्वेश्चन इज वेदर ए मर्डर्ड बी. ये रॉबरी के अंदर हो गया. कोर्ट कैन एग्जामिन थर्ड पार्टीज टू प्रूव दैट हियर यस, ये आदमी रॉबरी किया, मिस्टर बी ए ने रॉबरी किया बी का, मैंने भी देखा, इसके पास पैसे थे. हाँ, और वो शॉपकीपर भी बोलेगा मैं इसको कड़का बोला, उसने मुझे ये स्टेटमेंट किया, तो मेरे सामने 3-4 लोग आके इसको गन निकाल के पैसे ले चुके. सो देयर स्टेटमेंट इज रेलेवेंट. इट इज नॉट जस्ट द योर फ्रेंड, but the persons and passerbys who are present and the persons to whom he was proclaiming or boasting or stating are relevant. B, the question is whether A murdered B, a crime, marks on the ground produced by struggle or nearby place where the murder was committed are relevant fact. So यहाँ पे two friends went to a beach. इस बात पे झगड़ा हो गया उनका, तो it resulted in the murder of, a big struggle between them. It may be friend or you have been attacked by somebody. It is not just that किस तरह से अटैक किया, किस तरह से मारा. तो वहां पे बीच के ऊपर आप जहां बैठे थे, दी सैंड वाला के ऊपर, योर स्ट्रगल मार्क में भी आपके पैर के, हाथ के सब फोटोग्राफी खींची जाएगी. द काइंड ऑफ स्ट्रगल. सो ये सैट ओवर बी, उसके मुंडी को मालूम नीचे कर दिया और रेती में खोद के इसको डुबा दिया, मरवा दिया, वट एवर मे बी. सो one of the gentlemen, you or me, we were passing through, we saw this and we lodged a complaint to the police station. The police immediately came with the cameras. So cameramen came and took the photographs of the scene of offense. उस scene of offense में ये जो जगह में जो marks किस तरह के struggle के, to prove that there was a commotion, the struggle between them, which resulted in the act. Well, one of them may deny that. He may take up the plea of alibi. मैं तो बीच पे था ही नहीं. I was in Alibag. I was in different place. Like yesterday, one of the politicians took the plea before the court of law. No, at the time when the farmers died, I was not there in the scene of offense. I was there elsewhere. Normally, plea of alibi is taken under the provisions of Section 11 of the Evidence Act. I will tell you that. So to prevent this alibi plea, the police officer, the investigation officer will call for a team of experts कि यहाँ पे मार्क्स वगैरह का प्रोड्यूस कीजिए, स्केचेस बनाइए, इसके फोटोग्राफी लीजिए इसके अंदर. So they are the effect or cause, the cause of struggle. It is also in effect. कितने खड्डे हो चुके हैं वहां पे, रेती के ऊपर दोनों का स्ट्रगल बढ़ा, और he wanted him to bury him, or he dug up the entire, what you call it, sand. Use of photograph, ये produce, these are the causes and effect, and the passerby who was standing by, they can give. People who were taking a walk, they can give evidence. People who are fishermen who are standing boat can give it. It can be any place. It is not just a beach or any place. They can be fingerprint mark क्या भी सुनेंगे आपने. If you hold a particular item, आपके fingerprint mark आ जाते हैं. So people cannot deny कि नहीं था उसके अंदर. So these are experts who lead a chemical analysis. The reports you come to know, कौन कहाँ था, ये क्यों दिया गया. These are called indirect circumstantial evidence में ये prove होता है. So these are something, facts which are the occasion, the cause and effect are brought before the court. So this is normally admissible in circumstantial evidence, where the accused takes up the plea of alibi, takes up the plea that he is an innocent man, he was not there, story is planted. So इसके लिए prosecution has to do a very tight job, a very good prosecution. Prosecution must do proper investigation, collect thorough evidence. Okay, next. The question is whether A poison B, the state of B is held before symptoms ascribe to poison. So you have A and B have a litigation going on in the civil court. We will invite him. Arey, come over a meal, will settle the matter across. Why we want to fight it out? Both of them are healthy people. Sign. मालूम हो गया, बुला के घर पे खाना खिला के जहर डाल के पिला दिया, मार दिया. So what was his state before he went to have the dinner with him? That evidence can be given by his wife or the regular medical practitioner who has been in touch with him, or many people who are known to him. He is an active athlete, takes a walk every day. He has been keeping fit, and after taking poison, ये हालत होगी. Before poison, इसकी हालत खराब होगी. So that is the cause of poison is the result of death. That is the cause and effect of death here. Yeah, which afforded, okay, peace, health, and B. Newton afforded the opportunity for the administration of offense are relevant. Now I will examine tomorrow with you. I will discuss two cases दूंगा मैं आपको, at least one or two. That is, one is R.M. Malkani versus State of Maharashtra, yeah, 1973 Supreme Court. It's a very leading judgment. Evidence which is secretly collected or illegally collected, you may call it, through tape recording. Tape recording evidence records the cause and effect and the occasion that fits in section 7 that I will discuss with you tomorrow when I discuss before proceeding with section 8. Please go through R.M. Malkani versus State of Maharashtra. कुमार ता निकाल लीजिए उनको. AIR 1973 सुप्रीम कोर्ट है. R.M. Malkani versus State of Maharashtra. It's a very interesting judgment of the Bombay High Court which went to Supreme Court. A coroner of Bombay, he is a judge who is supposed to give a certificate after holding inquiry as regard the cause of death of a patient. तो ये जज साहब तो ऐसे निकले. He told the doctor, if you want me to give you a clean sheet, you have to give me bribe. I mean, bribe नहीं बोला, you have to give me, make me happy. 20,000 लाई है. 1973 में 20,000 बिग बड़ी अमाउंट. के बाद में सेटल हुए कुछ 15,000 के ऊपर. That gentleman was clever. He recorded these statements and reported to the police. Whether the issue before the court of law, whether such evidence can be recorded. So somebody asked me a question, you may ask, ये right to privacy के अंदर आता क्या? We will discuss it. Something which has been collected evidence against your will behind your back, or you may call it illegally collected evidence, can it be used? Because there are certain legislation which prohibit you that you cannot do phone tapping, you cannot do recording of evidence behind the back. किसी और का लेटर्स आप दिखा नहीं सकते. वो चीजें डिस्कस करेंगे हम नेक्स्ट लेक्चर में, दैट इज मंडे. ओके. R.M. Malkani वर्सेस स्टेट ऑफ महाराष्ट्र का मैटर जज में पढ़ लीजिए आप. इफ यू कैनॉट लोकेट आई विल सेंड इट टू यू. कुमार ग्रुप में डाल देंगे. देन दैट इज आल्सो इन अमेरिका दे नोन एज इंग्लैंड में इज एक्सेप्टेबल दिस काइंड ऑफ एविडेंस. अमेरिका में USA में इट इज नोन एज fruits of poisonous trees. Evidence is not acceptable. But whereas in England it is acceptable, India में acceptable. Rafale का केस भी देखें आप. And R.M. Malkani is a leading judgment. And even the division bench of Delhi High Court has recently said it. But you cannot invoke Puttaswamy judgment said that privacy, right to privacy is a fundamental right. Yes, no doubt. All your fundamental rights are not absolute. They are subject to reasonable restriction. अभी issue भी आया Pegasus, which the government of India has purchased it from the Israeli company. Is supposed to be using against many people, including their own politician. Of course, the government is not committing anything because taking up the plea on the ground, it's the affair of the state and privileged communication. रफाल के बारे में भी पढ़ लीजिए आप, कुछ पैसेजेस डॉक्यूमेंट एविडेंस हैं. There are certain evidence, illegally collected evidence. Can the court allow it or not? The presently is a Pegasus, which you may go through. It's a very contentious and delicate issue before the court and against the government. And we will discuss in the light of the earlier judgments. One is of Nagari's case in the year 1962. The landlord who demanded illegally from the tenant certain money wanted to bribe the municipal corporation. Nagari's case. And secondly, this is R.M. Malkani versus State of Maharashtra. They fall under Section 7. I will discuss with the judgment. पढ़ेंगे relevant portions. पढ़ के आइए आप. With this today we'll wind up. Anybody has any questions? Please let me know. I will answer them. Hi, anybody has any questions? So today we are. जी बोलिए.
Yes, sir. Sir, so these tape recordings, can it be also used for defamation? Like the countersuit, can it be called a defamation of character if it is leaked?
Yes, I will discuss with you tomorrow. Yes, it can be used. There is no bar. If you go through the judgment of R.M. Malkani, if evidence is illegally collected, it must be relevant. Kya? If evidence is relevant, it can be used. The Indian courts do not debar you from exercising. It has the cause or effect or occasion. Section 7 is very wide. It doesn't say that. See that kitna wide indulgence दिया गया है. Immediate or otherwise are relevant. Evidence which has the occasion, which has the cause or effect, immediate or otherwise. It may be relevant to fact in issue or relevant to the other facts. Fact in issue or relevant fact. And its constituting state of things under which they happen and how it happened. It doesn't say it should happen legally or illegally. समझे ना आप? Or affording an opportunity for their occurrence. So there was an opportunity to occurrence because the man demanded bribe. That is why I recorded it. A transaction that gave an opportunity. I reported the matter to the anti-corruption. Even if you record some conversation on your phone call, you can prove it, provided you have obtained certificate under Section 65B. वो भी discuss करता हूँ आपको मैं. Please note
Yes,
that recording. Okay, next lecture में discuss करूँगा मैं आपको ये important judgments. That is R.M. Malkani. If you, those who are interested, another judgment which I gave you, Rafale judgment देख लीजिए आप. Pegasus का discuss करेंगे. Without making any comments against anybody, let us be respectful in our comments. We are not supporting any party or agree as per the law that declared. Because we had to be apolitical while discussing the matter without supporting or without denigrating anybody. Not to show any disrespect. It happened how the court decides. We are only concerned with how the court decides, how it is relevant. वो कराएंगे हम लोग discuss करेंगे. 3-4 judgment I will discuss with you. I will also share the judgments to you by tomorrow. And Monday को discuss करेंगे. Shall we wind up for the day? Today we have covered 5, 6, and 7, 3 sections. Of course, we give some outlines of the other sections like section 9 and 11. वो अलग बात है. Is that clear for today? Is anybody has okay? Anybody has any question? No question. Shall we call it a day then? Ashutosh, shall we call it a day or not?
Yes, sir.
Okay. अभी क्या अभी I had to go and do stop recording. Right now? 3 dots में जाके stop recording करूं अभी? Ashutosh?
Yes, sir. Yes, sir.
Ji?
Yes. I'm facing network problem.
Network problem. So, okay. So I will turn the app stop recording. Okay, then all of you, good night. See you all. We'll see Monday. Okay.
Thank you, sir. Good night.
Thank you. Bye bye.